Good morning, good afternoon, and good evening, wherever you may be tuning in from across the globe today. My name is Michael McEvoy. I'm the Information and Privacy Commissioner for the province of British Columbia in Canada. I want to begin by acknowledging that I am presenting to you today from the traditional territories of the Kwanghan people, known also as the Songhees and Esquimalt First Nations. Thank you all for joining us today, and welcome to the first edition of what will be a regular series of Commissioner conversations throughout the year. It just so happens this inaugural conversation coincides with Privacy Awareness Week. Privacy Awareness Week is a global effort initiated by the 20 members of the Asia Pacific Privacy Authorities, of which BC serves as Secretariat. Our theme this year is making privacy a priority. And I think it's clear that this theme conveys a sense of urgency that is appropriate given the world we find ourselves in more than one year after the COVID-19 pandemic. There has been a rapid and massive shift online during the pandemic, without question. The video conferencing we're doing today, virtual doctor's appointments that some of you may have experienced at this point, remote work, it has helped us tremendously over the past year, these technologies. However, the shift comes with pressing privacy concerns, which is why we're here today to discuss privacy in the age of COVID-19. I am absolutely delighted that three global thought leaders in this complex space can be with us today to engage these issues. Our panel today is comprised of Dr. Jennifer Stoddart, former Privacy Commissioner of Canada, recipient of the Order of Canada, and she's currently a strategic advisor with the global law firm Fasken. I'm also very grateful that Jennifer serves as a member of my external advisory board. David Loukidelis, QC, former Information Privacy Commissioner for British Columbia, former Deputy Attorney General for BC, who continues to influence matters of access and privacy through his national and international consulting practice. And finally, my friend and colleague, John Edwards, Privacy Commissioner of New Zealand, reappointed to his second five-year term in 2019. He is highly esteemed among global regulators and sits as an executive member of the Global Privacy Assembly, whose 130 members seek to provide leadership at an international level for data protection and privacy. There's a Q&A function, as most of you will probably know, on Zoom, and you can just pop questions throughout the proceeding. If something grabs your attention and you want further elaboration on something, please do send a question. We'll try and leave a little bit of time for Q&A, maybe about 45 minutes past the hour, something like that. And we'll go from there. So please feel free to do that. And speaking of questions, I did want to start actually down under, at least from our perspective here in North America, John Edwards. And I start with you, John, because I have to say I'm still a little shell-shocked from a conversation we had about a week ago. I asked if you were in the office. Not only did you say yes, you gave me a pan shot around the office, and it was full of people. Which is just a strange foreign sight to most of us here. Things are very different in New Zealand in terms of fighting the pandemic. And I guess a lot of people do wonder, they see that and look at it with some wonder, but they wonder if perhaps in getting to where you've gotten in your country, whether it meant losing some ground in protecting people's information and privacy. John.
Thanks, Michael, and kia ora koutou katoa. Thanks to British Columbia, Michael, to you and to your office for the leadership and for the invitation to this. And I also want to acknowledge the First Nations that you spoke of earlier. It's a mixed answer to your question. I mean, I think one of the reasons that we've been able to be successful and have a combined community effort to stamp out COVID is this sense of common purpose, which at its heart has a large component of trust. And the trust is formed and maintained in part by really clear undertakings about what is happening to personal information. There has been here a social contract. People have understood that there are going to need to be new collections and uses of personal information in order to combat this pandemic. But there's been also an implicit undertaking, sometimes explicit, that must be proportionate, that must be only for the purposes of the pandemic. So we have actually seen privacy by design threaded through all of the pandemic responses. And my office has been deeply involved in providing that guidance and that sort of consultancy service through the legislation that's been required, through the contact tracing app that's been issued that now has the Google, Apple exposure notification framework threaded in. So yes, there have been some compromises of privacy. There's been some victims. It's very difficult in a small country like ours, which is about the size of British Columbia, I think, in population, for a public health official to stand up and say, if you were at this gym at this time, or this liquor store at this time, or at this bar at this time, to not have that, identify an individual and expose them to public comment and sometimes even social media vitriol, even though you're not naming them. So we've seen some of that. We've seen some trade-offs, but I think overall it's been accepted in the community as necessary and proportional, and we've got a way of backing out of it. All the legislation that's enabled these extra powers has sunset clauses to it. So look, let me just pause there and throw to David for his observations on this.
Well, as a recovering regulator, I'm very grateful to be able to join you, John, and you, Michael, and of course, Jennifer, my old friend and colleague. And I'd like to begin by acknowledging that I'm speaking to you today from Treaty 6 territory in Alberta, the province of Alberta, traditional ancestral home of many Indigenous nations, Cree, Saulteaux, Blackfoot, and so on, a gathering place here in Edmonton for many millennia of various peoples, as well as their ancestral home. A number of things you touched on, John, I can certainly echo from the Canadian perspective. So taking one of the last points you made, we have had emergency powers, rules or orders made that enable information technologies such as the one we're using today to happen, free of any concerns around data residency rules that would otherwise apply. These two are time limited, of course, and in the case of the data residency rule, it may raise issues around law reform that need to be addressed. Certainly in my view, they need to be addressed and reforms are needed. I think, though, that it's safe to say that there has been a proportionate response here as well in Canada. Consultation with the various privacy commissioners across the country, with federal, state, of course, and the contact notification apps to which you referred, John, are a good example of that, where there was consultation with the provincial and territorial and federal commissioners around that to ensure that a privacy by design approach was taken. And we've had some struggles around transparency in terms of the disclosure by governments of exposures or case counts and so on. I know that you, Michael, Commissioner McEvoy, you had issued a decision a couple of months back under the public sector legislation around whether or not it was in the public interest to disclose at a very, very granular level actual case counts and exposures in the case of Indigenous communities in the province. And there's been quite a lot of discussion in the media, of course, about whether there's been an appropriate balance between, on the one hand, transparency in the interest of public health measures, or so it's said, and individual privacy as well. And I think that it's safe to say that in British Columbia and elsewhere, government practices around disclosure of this kind of information have evolved over time. And we're seeing in BC, for example, I'm aware now, some pretty granular case counts of what are called the local health areas, which are quite small subdivisions of the health service there. So it's giving people a more granular picture of what's going on. Anyway, just in response to what you had to say, John, I fully agree that we're confronting or dealing with the same issues here in Canada.
Yeah, and on the topic of granular responses, Jennifer, sitting from your vantage point in Quebec, you work with a lot of private sector clients as well, striking that balance between what's disclosed and what isn't, and is privacy seen as a trust building mechanism from your perspective, or is it seen as an impediment as we try to get our hands around our minds around this pandemic? Well, I think we have lost your volume, Jennifer. I'm not sure what's going on there. I'm sorry. This is the wonders of technology.
Can I speak on the wonders of technology for a moment, Michael, just while Jennifer's organizing herself? Because David made an excellent point in our exchange of notes in the preparation for this, that there was a leaping towards technological solutions. And that really resonated with me. What I saw, what we observed in international pandemic response was a reliance on science. Every decision from public health authorities was based on peer-reviewed science that was coming from World Health Organization and good statistics. But every country in the world also leapt on these unproven technological solutions with no evidence base whatsoever, based on this absolute faith that the technologists would be able to save us. Now, we're over a year in. I still haven't seen any compelling evidence that all these vast aggregations of personal information have made a significant difference to the pandemic response. So I think it is important to reflect on that. I mean, I do think innovation is important. I think it's important that we try these solutions, but let's do so with a dose of skepticism. Let's be prepared to review these things on an ongoing basis and throw them out if they're not actually making a contribution.
Yeah. Jennifer, let's try one more time. Oh, I am sorry about that. We'll continue. We will continue to try. I think you're unmuted, but still we're having a struggle hearing you. So hopefully these things will click in. Many apologies for that. So I think, yeah, the point is made. I know early on in British Columbia, the thought that if you could get data at a neighborhood level or whatever, and you see some of this in other jurisdictions, not just in Canada, but other places, you wondered, and I think the public health officer here wondered what value that would serve. Would it tell people to perhaps not take things as seriously as they might otherwise take in them, or somehow relax standards that the disease is kind of everywhere all the time? That's what people need to be thinking about. It's absolutely, I think, a challenge from that perspective. Vaccine passports is another thing that comes along with all of this, and this is something that's very much on the table here, and obviously not just in Canada, but internationally, as people thinking about getting back into the travel world, international travel, but not just that. It's at a travel level, it's at a employer-employee relationship level, it's potentially a card of people, being admitted to certain places. This is a challenge. I think there's the concerns that in fact that might lend itself to tracking, amongst other things, human rights issues. What thoughts do you have on the vaccine passport issue as we come into this world? I'll let David or John, and hopefully Jennifer will be able to pop in at any point in the next few minutes.
I'll and if I might first say, I fully agree with John's perspective in terms of the need, one would hope, for privacy researchers and those who research technology and study technology to take away lessons from this pandemic, to actually scrutinize in a careful, rigorous, analytical way some of the measures that have been undertaken in terms of aggregation of data and so on, just to make sure that, frankly, when the next pandemic, next public health emergency comes along, we've learned from perhaps some of the missteps here and can do a better job of it, next time around. There's been lots of talk about vaccine passports, of course. I'm old enough to remember, and maybe I'm taking a retrograde view on these things, that when I was a child and traveled in Europe with my parents, I had to have my vaccine passport with me to get into a number of European countries. You had to prove you had yellow fever vaccine and so on. We don't have specifics yet. And although it's, I think, right to, as John said earlier, ensure that we take a proportionate approach to things, that there is a privacy by design approach, There are a number of initiatives underway, whether it's the European Union's announcement the other day or the World Health Organization, IATA, and so on, that as things evolve, most I can say right now is I think it can be done in a privacy protective way, a decentralized token, if you will, that individuals control in terms of being able to demonstrate their vaccine status, their health status, certainly when they cross international borders. I think that more troubling or potentially more troubling or vexing issues are going to be domestically when people are, as in Israel, for example, being expected to show a vaccine certificate in order to get into a restaurant or a concert or what have you. And I think that some of the human rights issues that raises, never mind privacy, could be much more vexing in the international context.
Yeah. Let's try out the technology. Jennifer, I know we wanted to wait in earlier, and let's try that again.
Can you hear me now?
We can hear you. Fabulous. Great to hear your voice.
That's great. Okay. I think I have these problems periodically. I think it's because I work behind the many, many walls of Fortress Askin that has to protect all the highly confidential information it has. So at what point are we? I'm sorry, I was talking to the technician. What's your question at this point?
Well, I did want to come back to you kind of on the state of where privacy and protection of people's information is, and just in the course of the pandemic, whether the measures that have been taken are that you've seen from your perspective in Quebec and in Canada, and you also have a global perspective, whether those are proportional, whether privacy is seen as helping to build public trust in a time of pandemic, or whether it's kind of becoming seen as an obstacle for some in terms of ridding ourselves of this terrible disease.
Yeah, maybe I'll just talk about what I see most directly Can you hear me?
Yes.
Most directly from where I am in Montreal, and as I was pointing out, a place where many peoples over history have coalesced. I don't hear a lot about privacy. In Quebec, I don't notice a lot of debates in mainstream media. Now, I don't spend my day, that's the luxury of being retired, following all the chat rooms. I'm not on social media, etc. But in mainstream life, there isn't a huge amount of debates about privacy. What there are debates about is loss of liberty, loss of freedom, and we could talk about that. I'm surprised that the Federal Emergency Powers Act was not invoked over the last year and 2 months. Mm-hmm. I would have thought it would be. That's an interesting comment in Canada about where governments are and how they hesitate now in today's climate to invoke something like the Emergency Measures Act, which certainly has clauses. It was just redone about, 1990, that would deal very efficiently with this kind of issue. So that's something I think to note. Governments in Canada anyway really hesitate to use authoritarian powers. I know David was speaking with authority as usual on the app tracking and its permutations. I'm surprised at how the app as the scientific solution to everything, as John Edwards pointed out, turned out to be a bit of a waste of time, a waste of resources. It certainly got privacy commissioners having to comment on it, and it ruffled a lot of feathers, but it turned out to be ineffectual, unused. I think that's one of the big takeaways about people not wanting to be tracked and not wanting to refer other people. And so the value of the data thus collected, I guess, was inconsequential. So those are some of the things I've noted, but most of all, thinking about what had happened today, I think people don't really talk about privacy a lot because governments have not gone to where they had in the when they imposed the War Measures Act, for example. So there's very few people talking about their civil liberties. There are some, but this is mostly in terms of freedom of circulation.
Yeah,
which is not synonymous necessarily with privacy. There is some overlap. So
Yeah.
that to me is, you ask these questions would be surprised.
Yeah. Although I have to say, I thought in Canada, at least when the this app, contact exposure app, I guess it's more properly called, how carefully and gingerly the government walked. Very concerned that people would be concerned that it would be kind of a tracking device and imposing on their privacy. And the pickup has actually been very poor. But John, that's not, I think that's a global phenomenon, is it not? In terms of the traction that these apps have had globally, you kind of got a perspective as well as on your position with the Global Privacy Assembly?
Yeah, I mean, I think the uptake it's got to be very, very high in order to be effective. And I don't think we've seen any jurisdictions in which it's reached that optimal level. Yeah, I mean, it just hasn't really been communicated particularly well. I mean, in New Zealand, there's been a real emphasis on ensuring that people are aware that the device is there simply to give people a personal diary to aid their recall if they need to be able to tell where they've been, and that it is not stored centrally in any sense until and unless there is a positive diagnosis and with the consent of the individual. And I do see around the world where governments are able to give that reassurance, then the uptake rates are improved. It was very interesting to see in Singapore that they started with very high undertakings of confidentiality and pandemic limited use. They got a pretty good uptake. I mean, they didn't get near that clinically important sort of tipping point, but they got over a fifth of their population, over 1 million people, maybe would have been more than that. And then in January, they had a change of policy and said, well, actually, the data from the contact tracing will be available to law enforcement. And I think, I haven't seen any studies, but I'd be really interested to see how that switch affects the willingness of the population to engage with those kinds of technologies.
Yeah. One of the things thinking about as digital uptake has just generally exploded during the pandemic. One of the things our office has seen, I don't know, John, in your office and your observations, Jennifer and David, but we've seen an increase in breaches. Some of it's having to do with the fact that workplaces are becoming remote and all kinds of other things. A significant actually jump, even though in British Columbia, I have to say, we don't even have mandatory breach reporting. We encourage people organizations and public bodies to do it. Nonetheless, there's been an uptake. It's, in some ways, I think some would argue, expose the need for privacy law reform. And as the uptake of these technologies has exploded, the legal framework that oversees them hasn't necessarily kept in pace. I just throw that out to you. I don't know, David, maybe start with you and go over to Jennifer and John.
Certainly, anecdotally, I've been hearing of an increase in breaches. A lot of them are the garden variety, if I could put it that way. If somebody leaves a laptop in the backseat of their car, it's stolen, it's unencrypted because there are more people commuting to and from work. There's been an upshot in those kinds of things. Obviously, technology such as this introduce security issues, security risks if they're not done well. I don't know, this might be, maybe I'm being unimaginative again, but I'm not sure that I would agree that the rise in use of digital technologies and a sort of associated increase in privacy breaches necessarily makes a different or new case for reform in privacy laws. Certainly long overdue in BC, and we would hope to see that coming soon, but that's for other reasons, not because of the pandemic, in my view anyway. I'd be interested to see what Jennifer and John have to say about that.
Yeah, I think it makes the case for reform, certainly in the jurisdictions that I'm most familiar with, for relooking at health law and how within health law, which in our country is separate from data protection law usually, one shares information, health information, we're all there, with others. And that is a debate that is coming, but I don't see that it is, it's reached a crescendo, shall we say.
Yeah.
Okay,
Yeah, look.
is it working? Enough to really move. Certainly in Quebec and Canada, we've seen some major introductions of reform to data protection law, some of which would affect, but marginally, the handling of a pandemic and the associated data, I think, but they're bogged down for two different reasons. So it's a very kind of puzzling time. It's getting curiouser and curiouser.
If I can jump in, Michael, we actually had privacy law reform contemporaneously with the pandemic. So the law was passed its first reading, Privacy Act 2020, in about July. It came into force on the 1st of December last year. It provides for mandatory breach notification. It provides for the commissioner's powers to issue compliance notices, not big fines and stuff like you have in the GDPR. We're short of the GDPR in a number of respects. But when I look around and see the kinds of issues we've had with the pandemic, I'm not sure that they make a case for law reform. I don't know that the law is sufficient. A couple of examples for you. We had a subway worker, that's the sandwich shop, not the mass transport. We don't have any mass transport in New Zealand. But this guy used the contact tracing register to stalk a woman customer on her social media. We had a security guard at a managed isolation facility Snapchatting himself with a list of the people at that register. We had politicians leaking to the media spreadsheets of people who were in managed isolation that in turn had been leaked to them by somebody in an emergency service. So each of one of those is pandemic specific, but doesn't create any particular challenge for the privacy law framework. I think our privacy law framework can cope with that. And in the latter case, the political consequences of that leak were very significant. So we see public opprobrium for a lack of respect for privacy, probably as great or even more significant than the kinds of incentives you get with the sorts of powers you might be seeking if you had a law reform process.
Yeah. One of the things, and perhaps this is a more general question outside of the COVID parameters, but in terms of how privacy law applies, not just COVID, generally, some skeptical wags recently said, well, don't worry about things. We have an independent oversight board at Facebook that will take care of the challenges that we're facing. But I mean, in many ways, the data things that began to happen at a significant level, talking about Facebook, Jennifer, you were Commissioner of Canada, probably launching the first significant investigation of Facebook back in 2009. As privacy regulators, we were kind of the first responders to the scene in many ways. But I think the world is evolving, and it has struck me in the time of COVID, when we've had challenges like the vaccine passport, which kind of didn't involve just us, a collection of data. It involved human rights. What about the case where the vaccine is distributed unequally, and if it's going to be a passport to get in somewhere, or the fairness of it, the ombudsman's role? So where do you think this puts privacy regulators generally now in this whole framework? And we have anti-competition laws happening that are trying to get some of the same issues that we as privacy regulators have been trying to get at for years. Where do you see privacy regulation in that whole schema as it presently sits in 2021?
Michael, can you hear me?
Yes, indeed we can.
Okay, at least, yeah. Good. Michael, for a long time, I don't want to shock anybody here, but I have thought that as privacy, access to information commissioners, radio, television, regulatory authorities, and part of the functions of competition regulators and so on would be amalgamated into one. I think the division of powers reflects the world as it was in the 1980s. And I think it's inevitable that we redraw the regulatory landscape. I can say this as a retired commissioner, I'm not involved, but you know, I used to talk to it with about it with other heads of agencies in Ottawa, and it's, you know, without doing a Marxist analysis, I think that the regulatory function will follow the technological superstructure that it's built on, which is increasingly the internet. And so we're due for a shakeup. We see that in the UK's introduction of a data commissioner, one mentioned in the speech to the throne, which had already been mentioned in a ministerial mandate letter a year before. So I think the writing's on the wall, but at the rate things go, you know, it won't be for 10 or 15 years. It'll be for another generation to take this challenge up, in my opinion.
More commissioners. Do we need more commissioners? John, do you have any thoughts on that question?
Yeah, I do. And to a certain degree, I echo Jennifer's comments. I would add one sort of regulatory authority that she left off that list, and that would be electoral commissions, because increasingly we see these platforms interfering with or influencing democratic processes in a way that I think is really undermining. But I certainly do agree that we need to have, if we can't have regulatory change, we need to have a great deal more coordination, both domestically across these regulatory bodies and internationally, because the problem is one that I've defined in conversation as they are one and we are many. You know, we are many privacy commissioners. They are one Facebook, one Google, one Airbnb, whatever it is. That's the model of the digital age. There can be only one, right? One video streaming service. And they exploit that. We simply don't have the regulatory or even the fiscal firepower to disrupt those. So there needs to be a coordinated international effort to define and plan a future regulatory framework of the sort that Jennifer has described. I mean, just in our neighborhood, recently in Australia, the Australian Competition Authority and Consumer Affairs Authority, called the APPA, has taken a case which is right squarely in the wheelhouse of data protection. We're going to see this more and more often. We see it with the, you know, it's a sort of FTC model. But what they've done is make a ruling that Google's default location tracking of Android devices is unlawful from a consumer trade practices perspective. Meanwhile, the OIPC, my counterpart there, you know, Commissioner Angeline Paul, is busy issuing proceedings against Facebook for their role in Cambridge Analytica. So there is this kind of division, which I think those platforms are quite happy to see and to exploit. And until we can kind of bridge these and have a coordinated approach, I'm not sure that we're going to get the kind of headway that we need.
Yeah, David?
I would agree with everything that's been said. I mean, this idea of dividing and conquering, that, you know, they are one and we are many, is absolutely increasingly, I think, a real challenge to a coherent, frankly, and effective approach to data protection, privacy protection, alongside the many other public interests that are engaged by this. And you know, Jennifer, you mentioned, you know, the mandate letter here in Canada and the idea of a new digital commissioner, which the details of which I'm not familiar with anyway. And it certainly, if what's intended when the budget, the throne speech says that commissioner will complement the roles of the existing information and privacy commissioners federally, if that is to be just a, if you will, a multiplication of commissioners without truly actually kind of unifying their efforts, I think that would be a negative thing, frankly, because this is a time when, domestically and internationally, I think there needs to be a more concerted effort to work across the various, if I could put it this way, subject areas. Yeah,
it's a slowly evolving process. Sometimes it's frustrating. I mean, you see in Europe with the General Data Protection, the board, with the attempt at one-stop shopping, you know, it's going through growing pains. In Canada, where we have 4 jurisdictions involved in the in the privacy world. I mean, we see in big investigations, we work very, very closely together. British Columbia, Alberta, Quebec, and the federal authorities. We did so in the recent Clearview investigation, Cadillac Fairview, just to name some. That work is ongoing. It's a large measure because we don't want companies playing regulators us off against one another, but it also is actually beneficial for businesses too and organizations that they're not having to deal on multiple fronts and know that the authorities speak with some authority. Now, one of the challenges is not all the authorities have the same powers at their disposal, which kind of complicates matters, which speaks to trying to harmonize the various laws, not just in Canada, but globally. And on that front, John, you're on the executive of the Global Privacy Assembly. Do you see any trends happening in the world that would suggest some convergence of principles underlying privacy laws that is going to help somehow getting us to that end point?
I think we're starting to, but it's not going quickly enough. And I think the problem is probably that most of our Western democracies, regulators simply don't understand the technology, and they don't understand the marketplaces, and they don't understand the problems. And that means we're not getting a coordinated international approach. I see potential at the OECD, and I think their review of privacy principles has potential to arrive at something which has a more meta denominator that people will be able to sign up to. But in the absence of that, you know, this is a problem that is becoming pressing, because I think that we're seeing a kind of regulatory and technological arbitrage where the development in some of the most harmful, potentially dangerous technologies is occurring in jurisdictions where the kind of rights side, the consumer side, is not prioritized. That means that they will get a market advantage with technologies that do not have privacy by design built in, that do not respect the rights of the individual. And if anybody's in any doubt, I'm talking about what's happening in China. You know, a vast majority of papers published on artificial intelligence at the moment, for example, are published in Chinese. Now, this is not xenophobic talk. This is simply a reflection of the regulatory frameworks in the West, plus also actually increasingly the kind of ethical reticence of even some of the biggest corporates to offer services such as retail facial recognition, such as AI, automated decision making, because the regulatory frameworks are not ready for it, because human behavior is going to take and exploit these technologies in ways that we can't even predict. We don't see that reticence in some of the jurisdictions that have not signed up to the kinds of standards that we think are suitable to a rights-based approach. And I'm really troubled by that. I think that's something that our international diplomacy needs to accelerate and coalesce around some high-level international standards of caution.
Yes. Jennifer, you've been involved in much international work on various fronts, your time as commissioner and beyond in your work. What do you see in terms of the potential for some kind of an international convergence, or John talking about some standards around some of these very vexing questions, including use of facial recognition technologies and other things?
Yeah, well, in musing on these questions that you're throwing out and that you did when you put this panel together, and I'm wondering, why don't we have privacy reform, and why are we moving so slowly at the OECD, and why do I live maybe a 40-minute walk from the global headquarters of a place called Pornhub, on which usually young women have their images put on there on their streaming services, and find it impossible to get away, to have taken down in a country that is, you know, devoted to rights and liberties, and so it says. You have this problem in many of the leading democracies now. It seems that we can't act on human rights, we can't act on the realization. I mean, we've known this for about 10 years now, right? That all these laws need reforming because of the emergence of the new tech and social media and so on. Most of us, I can't think of anyone who's really done anything significant. And I wonder if we can't link it to our split electorates at this point. I'm sorry, I don't know too much about New Zealand. That may be the exception, John. I think you re-elected your prime minister. But in countries like Germany, France, the UK, Canada, the United States, we have minority governments or barely majority governments. And I'm just wondering if the lack of action is because these governments don't sense a social consensus or an electoral consensus behind them to do these kind of things. And I think that might be one of the reasons why C11, our Canadian reform bill, is going nowhere. And I wonder, I saw a remark by the Minister Champagne, who used to be in international relations. And I'm wondering if it's because all these G7 countries are waiting to get all their ducks in a row. So they react the same way to the regulation of the internet and the monopoly companies that move on it. I haven't seen that, but I'm just throwing the question out as a reason for the stagnation in action.
Yeah, David, I see you had a thought there.
Yeah, I mean, I've often wondered over the years whether, you know, in terms of trying to push towards, you know, international standards, obviously data protection, privacy regulators have been working at an accelerated pace to work together and have had great input. Jennifer, your work with the OECD, for example, and John and Michael, your work in APPEC and the ongoing discussions around the APPEC privacy framework as examples. Whether making it a trade issue, if some way can be found to make this a trade issue, whether one of the supranational organizations might take this on and succeed in advancing an international consensus around some minimum standards, building on work that's already been done. That's probably pie in the sky, but it's something that I've often wondered about, whether there might be an inroad through that. One of those international fora, like the WTO, for example. But at a domestic level, I agree, there is a challenge really in, you know, initiatives like C11. I'm not up to date on what's happening in Quebec with the privacy reform there, Bill 64, and in British Columbia, where there is, you know, ongoing work on privacy reform. Hopefully will come to, you know, fruition soon, but it's it could well at the base, at heart, be a political issue domestically.
Yeah, now there's a number of questions that have arisen. Some have a common theme, and I'll just throw out a couple. Do the panelists have any observations on the privacy implications of the use of technology in learning apps and the like by children during the pandemic for the online learning? Of course, we've seen a lot of online learning in the course of the last number of months. For personal use, are schools being supported in making sound choices for online education tools? You want to jump at that? What's happening? I can only say, I mean, in British Columbia, what we've tried to do, realizing right at the outset, there were going to be a whole bunch of struggles that, you know, businesses going with remote work locations, schools, K-12 situation in particular, while universities as well going online. We have tried to provide as much guidance as we can as regulators that people need to be paying attention to as we move forward. British Columbia is complicated by the fact that we have data residency requirements, which the government relaxed, to be frank about it, to some order. I think they did it in a reasonably measured way, but it's something we have to keep an eye on. Schools and others using platforms where personal data is residing outside of British Columbia and perhaps maybe not used in the best way. So I don't know. But I don't know the situation in New Zealand. John, is that something that you've confronted at all in terms of the online learning? At least.
No, it isn't actually, Michael. And I think, you know, as in many areas, New Zealand, being a small nation, is a taker of technology. So a lot of schools will base their learning platforms on Microsoft 365 or other international offerings. We haven't seen any problems or controversy emerge. And one of the things that we have seen is a bit of consternation among some parents about the sorts of monitoring software that is used in schools, but that's not pandemic related. Some of these, some organizations some schools are requiring students to download apps that watch for certain triggering phrases or search items, whether it's their own device or not, whether it's at home or at school. And there's some boundary issues there, but no, I haven't seen any issues emerging in the education sector arising from the pandemic at this stage.
Picking up on the theme of whether international standards and convergence is possible, Jeremy asked a question that I think many of us have grappled with, is that are international standards even possible where there are cultural differences on what privacy means? David, you want to take a crack at that? John, go ahead, John.
Thanks. I mean, I think they are. We just have to abstract to a level that we can reach that agreement. I think it's an abdication of responsibility. And it shows the priorities of politicians, frankly, and others. We've managed to do this in cybercrime. There are international treaties and conventions. We've managed to do it in relation to cyber warfare. We've managed to do it in relation to copyright, for goodness sake. Now, the situation that Jennifer outlined, if I go to Pornhub with a DCMA takedown notice because somebody has infringed on my copyright, they'll take it down like that. If I go there and say, hey, that's my daughter, what the hell are you doing? They'll say freedom of expression.
Yeah.
Well, yeah, unless we got some laws, but I agree with you, John, and I think that we have to continue to try and have international, both data protection and privacy standards. If nothing else, the discussion about that is, I think, very, very sanitary, in that airs a lot of bad practices, about a lot of undemocratic practices to the glaring light of the rest of the world. And I think, for example, the work that Joe Catanacci, the UN rapporteur on privacy, who was named, about 5 years ago now, has been very useful. Certainly to the OECD, I think to the Global Privacy Assembly too, in your deliberations. That doesn't mean application needs to be identical, as each jurisdiction wants to hang on to its own culture in the pressure of a globalized world.
Yeah. David?
Well, in terms of convergence of standards and picking up on something John said earlier, it's interesting, or will be interesting to see, I think, what happens in the area of artificial intelligence, automated decision making, in light of the recently tabled or introduced EU regulation on artificial intelligence, just as the GDPR has a knock-on effect, or has had a knock-on effect. And that raises the question of, who is it that's going to drive policy and law in these areas? And what does the international conversation look like? Is it merely reactive and responsive? Or again, how do we engage on the international level to further the conversation, perhaps a richer way, if I can put it that way, regardless of supposed cultural divides?
Looking at some additional questions, our friend Mike Larson at the BC Freedom of Information Privacy Association, we've seen a significant shift to remote working during COVID-19, and this has resulted in the expanded use of applications that connect people to their employers, schools, providers, etc. Do you think that businesses and public bodies have the resources and knowledge in order to, somehow I've just lost the rest of that question, but that basically to have the wherewithal to deal with this, the shift that's gone on? David, you've well, and Jennifer too, have advised, I think, clients in this area as they're finding their way in this new world.
Maybe I could pipe in. FASCN has a huge part of its practice that is in labor law, and I'm not in that practice, but I see the emails going by, and of course they were like a dozen a day at the beginning. About what employers couldn't do, people being vaccinated, their privacy rights, their physical integrity, et cetera, et cetera. And I thought, oh, isn't this going to be interesting? Well, it turned out to be not quite as interesting as I thought, because the whole issue seemed to settle down very quickly. It went quickly. Some cases went quick arbitration. The labor, the ones that I read, more or less decided in favor of public interest, like, no, you don't have an absolute right to come to work if you're not going to have your temperature taken, things like this. And the issue seems to have been subsided fairly quickly. So the moral of this story, and I don't read any headlines by major unions saying that their workers are being traumatized or oppressed. There are a few issues, but I think the moral of the story is how quickly we can adapt to get things done in emergencies. So I've been very heartened by the institutional response to a lot of these individual versus need to work or need to learn issues.
Yeah. David?
Well, I was going to say, I would hope, at least with larger business organizations, if not the SME sector quite as much, that it would focus them on the need to ensure that at all times, for all purposes, they have adequate resources internally or available to them externally through law firms or other advisors to comply with their privacy obligations under new circumstances. And I suppose for privacy commissioners, if I might, Michael and John, it raises questions for regulators as well in terms of the adequacy of the resources you have to respond to the requests for guidance and consultation that you no doubt have been receiving more and more of in the last year or so.
Yeah. A question going back to part of a discussion we had at the outset, somebody asking, and again, the balance between disclosures being made by public bodies and authorities versus the right of people to have their personal information protected. Perhaps maybe a general question, but what level of granularity is the right one? Is this one of these things you know it when you see it from a perspective of a regulator, John, or is there a precise answer to a question like that?
No, there isn't, because the maths on this is far more complex than appears to the eye. It's, I can understand calls for greater granularity in communities, but what we've seen here is that if you have a couple of data points, you can identify people, and people are suffering quite considerably from being identified. Let me give you one example. We had in New Zealand, in the early stages of the outbreak, a local mayor went to his local hospital and said, have we got any cases in our district? It was a very large rural district. And the hospital said, yes, there's one case in X town. And he put that on his Facebook page. We've got a case in X town. Now, the granularity is a couple of thousand people in X town. You'd never identify them from that perspective. But the next week, the Ministry of Health said, we've got a cluster in this district, and it's associated with the Hereford Bull Breeders Association conference that happened in Queenstown. Now, everyone in that district knew there was only one Hereford breeder in X town. And so you've put those two pieces of information together, you've identified them. Now, that person wrote to me and explained her experience of having been outed in that way. And it was just horrible. She couldn't walk down the street of her town. She had to get permission from the police to drive 50 kilometers further to get her groceries. She had these indignities of even long after she'd recovered, being subjected to medical examinations in the car park of her medical clinic. So, it was really, I think when we talk about granularity in this context, a precautionary principle should be applied. And I think, kind of random rounding is one component of that. But health authorities should take really good statistical advice on the implications of releasing different kinds of attributes.
Yeah, and David, the kind of granularity, does it not create there are things to balance, but does not create a risk that people might even be just fear to report things because of what might arise as a result?
Yeah. I think that's an important point, Michael, and it's one that I know that public health experts can tell you has been a concern in other contexts, of other public health challenges or emergencies. And John's just given a really eloquent example of, you might say, well, COVID-19 diagnosis, it's not that stigmatizing and so on. Look what happened to this individual. And we have had examples in Canada. I can think of one in New Brunswick, for example, and that could deter people from self-reporting.
Yeah, and in fact, I can think of an example when I was back in Manitoba last summer when things had, we thought, receded on a permanent basis. Obviously, that not happened, but a Hutterite community was identified as a place of an outbreak. And the stigma that attached to not just individuals now, we're talking about an entire community who would, for example, go, various colonies would go into town to do shopping and so forth. And you could feel the tension. I could feel the tension in the air at places where we're going because of that identification. In that case of not just an individual, but a group. Yeah. I see we're 60 minutes past the hour. I just wanted to ask all three of you if you had any just sort of final comments before we wrap up in front of this significant audience we have in front of us today. Maybe to start with you,
well,
Dave.
Sorry, with the other two speakers in again thinking about the very profound and sensitive questions that you set up for us, Michael. I'm just wondering if going forward, certainly in the health area, if we have to desensitize a lot of the information. I wonder if we're being really helpful to ourselves as a society in trying to broaden the scope of privacy, or talking about, oh my God, if somebody sees my health records, this is a great catastrophe. Why? Because it encourages us versus them mentality. It encourages secrecy in ways that it's not always helpful. And I know this is a nuanced discussion. And I think that we're in a society where I would say largely for the better, there are fewer and fewer taboos. The very real and disturbing incident that John told us about is because we don't know how to handle information that up till now we have treated as being private and somehow shameful. I'm looking at one of the great social revolutions that's certainly happening in North America, most of Western Europe, which is the Me Too movement. This was something, I'm a grandmother at this point. When I was a young woman, nobody talked about sexual assault. Nobody talked about sexual harassment. And if you were raped, you knew, you just hoped to keep it quiet. And now things are coming out and out and out, and I think it's very healthy. I don't know that we're going to achieve long-term health control in terms of having a healthy mentally and physically societies in the face of coming waves of pandemics, if we don't find a more positive way to treat the fact that yes, I've got COVID or whatever, and so it's not rejigging the value of the information. It's how do we rejig society's reactions to these quote privacy breaches. So I think that if I were a commissioner now going forward, I'd say we have to think privacy in its basket of other social values, and we'd say rights and freedoms in legal jargon. So I'm a bit kind of off track compared to the other speakers about granularity and privacy.
Well, I think it speaks to, you've spoken to the whole issue of the cultural, how we view these things culturally in our society. And I think we take your point, but I guess it is what it is at this point. I know, I just see a comment from our colleague, Commissioner Libero in the Philippines, who says the unnecessary disclosure of personal information stunt government efforts to identify and test individuals with confirmed cases effectively and have serious consequences on the individual, which could prove far worse than the disease itself. Yeah, that cultural shift that may be necessary, I think, in the future, Jennifer. I don't know if it's going to be on the horizon in the near future, but I think I think you're right. These stigmas hopefully will be broken down over time. I'm going to go to you, David, for any closing comments that you have, and then John, before we wrap things up today.
Certainly appreciate hearing Jennifer's perspective. I'm going to be much more sort of granular and day-to-day, if you will. One area that I think is going to be of interest, certainly to me, is the way in which this pandemic has accelerated, I think it's fair to say, and expanded the use of digital health, so apps and so on. We did touch on this, I know, but I've had recent experience of being somewhat frustrated because of the inadequate privacy controls that are built into some of these apps. And of course, in Canada, we have a single payer, public health system, if you will, publicly funded health system. And the private sector is, and I'm not saying this is a bad thing because they're being innovative, but this private sector is driving change in a way that our publicly funded, government administered health system isn't necessarily, certainly in the immediate term, able to keep up with. And I think that that's a conversation we're going to have on another day. But I'll leave it at that with appreciation for joining you today. Wonderful to see you, John, and Jennifer, and thanks so much to you, Commissioner McEvoy.
John, any final thoughts?
Thank you. Well, Jennifer's really made a challenge to us to close on a controversial note. So I'm going to try and rise and meet that challenge. I think COVID has done a great service to privacy and data protection around the world. Privacy laws are seen by their opponents sometimes as getting in the way of innovation, as interfering with the sensible public policy response to emerging issues. And what the COVID pandemic has shown us is that privacy laws are sensible, they are general, they are adaptable, and they are able to accommodate emerging issues in this way. So I think that it's in some senses contributed to the license, the social acceptability of data protection privacy laws as being able to facilitate and accommodate and allow sensible responses to these issues and challenges to the whole of society.
Thank you. Thank you for that, John. The last word, so to speak. I do want to thank you, John Edwards, Commissioner for New Zealand, Jennifer Stoddart, for your contribution today, and David Loukidelis as well. I think it's been a really interesting, very wide-ranging discussion, and there are plenty of other questions we could probably have carried on for some period of time, but in the interest of time and of the panelists and our audience, we're going to conclude things now. But thank you all from across Canada and globally for tuning in this afternoon and this evening and this morning. And we hope to see you again in future conversations. Thank you all. Bye for now.